Hello there, my name is Stephanie Rohl, and I'm an associate attorney at Stone Law Offices in Northwest Las Vegas, and we're here for your 5 at 5. Today I want to do something a little bit different. I actually want to go over a case study with you to bring to light some issues that I see on a regular basis. Now, this is someone who had recently come into my office as a potential client for an estate administration matter. All we knew is a friend of the decedent had contacted our office, and we sent them a workbook, had them fill out some preliminary information. I sat down across the table with this individual, and she begins to tell me this story that her friend of many, many years recently passed away, and her friend always told her if something happened to call XYZ attorney. Well, she called XYZ attorney after her friend passed away and found out that they did not have any estate planning documents at all. Now, the decedent many years ago had written a letter to the friend saying, if something happened to me, I'd like for you to have my assets. Now, when I asked the person who was sitting across the table, the friend, well, do you have a copy of that document, or do you have the document? She very sadly told me that she couldn't find it, or she was in the process of looking for it but had no idea where to start. So we already have a couple of issues that are popping up here with this conversation. As we go a little bit further, come to find out that the deceased individual was divorced, never remarried, and had one child that was an adult. However, that child had been estranged from the family for a number of years, meaning there was no contact, no relationship with that estranged child. So for 15 years or so, that person has been out of the picture. So we're at the point where we have no estate planning documents to be heard of. We have potentially a holographic will, writing of the decedent giving her assets to someone else. We have a family member, a very close family member, who is out of the picture, and no surviving spouse at all. On top of that, the individual claimed that in addition to being a very close friend, they may or may not have been taking on some caregiving duties for the decedent in their last couple of months of life. So what do we do with this? Where do we start? Now, after getting the information about the assets and figuring out who the closest family members were, I had to discuss with this individual who was coming in for the initial consultation, you need to find any type of estate planning document there may be. You need to do your due diligence, search the house, look for a safe deposit box, pursue any and all routes that you possibly can to locate estate planning documents. I also went the extra mile to request from the local attorneys if anyone had heard of this individual or had a file in their estate plan, which is something that most estate planning attorneys would offer to do. If they don't have the file themselves, they would reach out to their network to see if anyone else has it, because we don't necessarily want to open a probate for intestate succession if there actually was an estate plan in place. So once we got through that hurdle, where I said, you need to look for this right away, I had to go the opposite route and say, okay, in the event that you are unable to locate estate planning documents, what is the next step? Well, the next step would be initiating a probate. And initiating a probate for intestate succession, meaning there were no estate planning documents to be found. When you open a probate for someone who does not have an estate plan, you have to notify all of their next of kin that that probate is being initiated. And then further down the road, once you get to the distribution provisions, what's going to happen is we default to the Nevada laws, which say look to the closest living relatives to give the assets to those individuals. So in this case with this woman, she wasn't married, but she did have a surviving child. Regardless of whether that child was estranged, that child is set to receive 100% of the assets of the decedent. And that's just how the Nevada law works. If you didn't have the children, but you had parents or you had siblings who are alive, there are all sorts of rules in place to figure out where those assets are going to go. And we can identify that for you quite easily by pulling up the statute and walking you through the family scenario. So, needless to say, the individual I was talking to was completely overwhelmed and distraught at the idea, one, of a probate happening, and two, of this daughter who was going to be receiving the estate. And that's not the type of conversation that I want to have with clients. I want to be able to sit down and say, here's the estate plan. This is exactly who they wanted to give things to. The person wanted to omit this family member or this other person for whatever reason. And we can go through and pursue the plan that they had outlined during their lifetime. Dealing with this type of scenario after someone has passed away, it's really overwhelming and chaotic for the people who are trying to step in. And in this particular fact pattern, we've got the additional issue of, was the friend really a caregiver or not a caregiver? If she is able to find the holographic will, is there a presumption that that will is void because the person was a caregiver? I can't say yes or no to that right now. It's something that would have to play out in court, but there's a lot of unknowns, there's a lot of moving pieces, and most folks do not want to have this happen with their family. And I'm not making this up. The individual who was in the consultation brought up the fact that there was a life insurance policy, and that life insurance policy had the ex-spouse identified as the beneficiary. And they were wondering if there was anything that could be done about that account, given the fact that there was a divorce. Now, beneficiary designations are a whole nother can of worm, but long story short, they're a contractual relationship with the company, and the company is obligated to pay out the assets or distribute the assets to the named beneficiary. So even though this gentleman was divorced from the decedent some time ago, he is scheduled to receive this life insurance policy. So this was an interesting case study. There were so many pieces to the fact pattern that were not lining up for this decedent and this decedent's family / friends. And I can tell you without a doubt that the best way to avoid this scenario for yourself is to set up an estate plan. That means picking up the phone, calling an estate planning attorney, making an appointment to go in and discuss what you have, who you'd like to leave it to, who are the people you'd like to leave in charge, and go from there to establish the plan. At Stone Law Offices, we provide you a helpful workbook to help pull in that information together so that you can be prepared for that initial conversation with an estate planning attorney. If you've identified a couple of similarities with your personal estate, with your personal situation, please go ahead and give me a call and we can see what we can work out to make the road a little bit smoother after you've passed away. Again, my name is Stephanie Rojo. I'm an associate attorney at Stone Law Offices. My number is 702-998-0444.